Good afternoon, everyone. My name is Tom Banky, and I'm the Manager of Communications and Development here at Forward Community Investments. And I'd like to welcome you all to today's webinar presentation, Nonprofit Advocacy 101 with Melissa Scholz of Scholz Nonprofit Law. Thank you so much for taking time out of your busy schedules to join us on this incredibly important topic. Before we proceed with today's presentation, I wanted to go through a few housekeeping notes that will ensure our time together will be most beneficial for all. I am sure everything that I'm going to share is nothing new, especially in these last 14 Zoom-filled months. But we want to make sure that everyone has an opportunity to make sure that they can participate if they want with questions or comments, and we feel that this slide will help create that environment. So first off, this presentation is being recorded, and I will follow up in an email probably early next week with that recording, as well as Melissa's slide deck, as well as any additional resources that will be shared with today. If you have a question or a comment during our time together, feel free to do so by utilizing the chat or questions feature on your Zoom toolbar. I will be monitoring these questions and comments throughout the presentation, and we'll be addressing them at appropriate times. At this point, I'd like to set the stage for today's presentation. 501c3 public charities have the right to advocate for policies and values that are important to their mission. In our time together, you will learn what is and what is not lobbying and who cares. Melissa will also spell out what constitutes prohibited election-related activity. You all have an important role to play in strengthening our democracy, advancing your causes, and growing resources for them. Our presenter today is Melissa Scholz from Scholz Nonprofit Law. She brings over 30 years of experience as a lawyer, fundraiser, policymaker, and community volunteer. Additionally, we will be joined by Forward Community Investments Chief Operating Officer, Tracy Hubbard, who will provide some real-life experiences reporting lobbying activities. So, without further ado, I'm going to hand things over to Melissa.
Thanks, Tom. And you're going to share the screen with me?
I just made you the host, so hopefully
Great.
You can share that screen.
Says I can't, but all right.
Well,
okay, I'll go ahead. It looks like now it just wanted me to.
How about now?
Yep, I got it. All right, and then I'm going to change the view here to a slideshow. Great. All right, does that look good to everyone? All right, so I'm going to move right along because we have a lot to cover here, and I want to give time for some questions. We do have a large audience today, which I'm thrilled to see, so probably won't get to all your questions, at least make it as interactive as I sometimes like to do. So just know if there's a lot of issues that seem to need resolution and follow-up, I will do that. And one way I might do that is to post a blog on my law firm's website, which I'll then also share with FCI, and they can share it as well. So thanks, worked with FCI for years, actually decades. So I'm thrilled to be here and support their mission. So couple key concepts for today is, first up, we're talking about advocacy. Some of that is lobbying, some is not. We'll get into that. I am focused on what this means for 501c3 charitable organizations. There are, of course, 501c4s, which can do unlimited lobbying, and some political. There are businesses who do some lobbying. But I am talking about the rules for 501c3s today. And so I'm going to jump right in. So first of all, one of the basic premises of 501c3 law or qualification is that you can't engage in any political activity, which basically means the opposition or support of a candidate for public office. However, you can engage in lobbying if it is insubstantial, and we'll get into that. like I said at the beginning, much of what people want to talk about in terms of public policy issues and educating the public, even other legislators, about issues probably doesn't rise to the level of lobbying. So that's why I'm hoping to empower you to know that you can talk about important public policy issues without crossing the line. And if you do cross the line and are engaging in lobbying, that's okay too. It just means there's some limits on how much of that you can do, and there may be some reporting requirements that go with that. And then the really important concept to keep in mind is I am going to start by talking about what the 501c3 Internal Revenue Code requirements are. There's a different set of rules at the state level, and those come more under the ethics laws of the state of Wisconsin or other states around the country. And we'll get into those as well. And then, of course, there are state and county lobbying rules as well. So not trying to scare you off, actually trying to encourage you in this front, but you do have to be aware of those different, the web of different sets of laws. And I will say, because of this web, it is common that coalition organizations are formed where their sole purpose is advocacy and lobbying, and likely a 501c4. And so that may be one way that a charity can deal with this, is contributing money to a coalition or to another entity that is undertaking the actual lobbying work and therefore is doing the reporting and having to keep track of all that and do those filings. So we'll touch on that briefly. But so I already mentioned advocacy is not political, and generally we could spend a lot of time on that, but I'm going to jump right in. One thing to know in this distinction is that ballot measures or referendums, so like recently the referendum that was on the Madison area ballot in November for funding for the public schools, that is a referendum and that is considered lobbying. So that is not political. In this case, the voters are seen like as the legislators. There are things I'm going to describe that are advocacy that can become political when they're done at a particular time of the year, close to an electoral campaign, targeted at voters, or identifying a particular candidate. I am not going to get into that detail. I think there's actually material up on our website that I did last fall on this topic, because then I was much more focused on where the parameters are in terms of political and lobbying. I think we're at a time of the election cycle right now where we're all mainly focused on how to get policies changed and how to make things happen now that we have certain people elected. And that, of course, before you know it, we'll be back to the electoral part. But for now, I'm focused mainly on lobbying. And just a little lawyer humor here. I know that this gets pretty detailed. I'll try not to bore you. Just know that we will share these slides. And so I am going to have to skim over some of this detail, and you will be able to go back to it later. So, all right. So I said that lobbying has to be insubstantial for a 501c3, and that is not defined in the statute, and it is a very vague test. So for certain organizations, it makes sense to make what's called a 501h election, which gives you an expenditure test. So for instance, if you have a budget of $500,000, under this test, you could spend up to 20% of your budget could be on lobbying expenditures. So that is helpful to have that kind of parameters, or that specific parameter. You'll see that the amount decreases, like for the next 500,000, the next 500,000. Ultimately, then there's a limit. Some organizations, like very large charitable organizations, very large, I don't know, like a hospital system, something like that, they would not make this election because insubstantial for them is actually a larger number than this 501H test would allow. The other benefit of making this 501H election is it gives you very precise, but it gives you definitions of what is and isn't lobbying, and you can rely on that, and then it ties in to reporting on the Schedule C of the Form 990. Okay, so if you make the 501H election, and I have a slide at the back, there's a form you file, you just file it once, and it's in effect unless you terminate it. Then you say, we're going to do lobbying, don't know how much, but we can spend up to 10 to 20% of our budget, depending on the size of your organization. And so then we have to start thinking about what's lobbying. And there's two different kinds. One is called direct lobbying, one is grassroots lobbying. So quickly, any attempt to influence legislation through communication with any member or employee of a legislative body, that's lobbying. So you'll see we get into the definitions here. I mean, legislation is really what you think it is, but it's also work in preparing for writing legislation. So legislative proposals. It doesn't have to have just been introduced as an official bill. And then communication, also what you would expect. However, there are two key parts to this. It must refer to specific legislation and to express a view on that. So in this case, obvious message to a legislator saying support the bill protecting wolves, and specifically. But if the message to the legislator is urging them to encourage the Fish and Wildlife Service to keep wolves on the endangered species list, that's not legislation, that's not lobbying. All right, and keep in mind, for it to be direct lobbying, you need to be communicating with a legislator or their staff. All right, so then get into the definitions here of what is a member of a legislative body. And so this includes city council, state legislators, county commissioners, Congress. And as I mentioned earlier, it also includes the general public as it relates to a referendum. But it doesn't include, usually, judicial, executive, administrative bodies, including zoning boards, which becomes quite relevant to local groups. However, there are times where executive officials are participating in the formulation of legislation, so very common to advocate for appointment of a particular cabinet official or a judge, Supreme Court justice, etc. That is lobbying when you're telling the executive branch who they should be nominating, who they should support, because in the end, the Senate confirms that action, and so that is legislative. So like I said, though, no limits on administrative advocacy, and I make a point here to point out that this is under this federal test. Unfortunately, I'm going to make your head hurt a little bit when I point out the Wisconsin rules, because that is different at the state level. All right. So then that's communicating directly with legislators. Then we have the issue of talking to the public. And I think that's where a lot of the activity happens, right, in the nonprofit space. So there's this concept of grassroots lobbying. And that is more limited. So of that budget, we'll just say the 20% budget, though that's for a very small organization, but for the 20% budget, you can spend up to 25% of that allowed amount on grassroots lobbying. So grassroots lobbying has a very specific definition. So it's communication with the public that expresses a view about specific legislation, and this is really the key part, encourages the taking of lobbying action or a call to action. So there are many communications that say the equivalent of the law. Okay, I started with wolves, so we'll just go on, even though my family makes fun of me on how I say that word, so I probably should have chosen something else. But protecting the wolves, you can say all kinds of things publicly in the media to to whomever is listening or reading your materials about why legislation is good or bad. But as long as you stop short of telling people what to do and telling them to call their legislator, to write in, to sign this letter, to sign a petition, something like that, then you are not engaged in grassroots lobbying, and you're not engaged in direct lobbying either, because you're not talking to a legislative official. So it's a really important distinction. Again, this is unique to a subset of nonprofits or 501c3s, but there is an exception for members. Won't get into the details, but just know that there are certain things that may qualify as grassroots lobbying, that when you are directing it at your members, it becomes direct lobbying. So that's just an advantage for certain communications. All right. So there are, oops, I'm gonna go back. There are, like I said, many things that don't qualify as lobbying because they perhaps miss that final call to action. Another just general carve out would be public education campaigns. I already said that either don't mention specific legislation or call to action. So tweets, social media, emails, without that. That's a member, sorry, that's a member role that just confusing. So I will pass on for that. And then under 501H, this is where the benefits of 501H really come in, is that there's a number of things that are defined as not being lobbying. And so that, I think, really helps give people guidance on how to communicate with legislators. So one of them is a carve out for discussing broad social policy issues without mentioning specific legislation. Of course, we've already talked about that. Another is responding to a request for technical advice or assistance from the governmental body or committee, so a request to testify. Preparing, distributing nonpartisan analysis. These are often called white papers. This is very common. You can do a full review of legislative options with opinions on what's good and bad about the legislative options, but you stop short of explicitly supporting one or the other, but you give a full pros and cons, and it just does not have to be unbiased. I mean, can have an opinion on what's a good outcome, but you stop short of supporting specific legislation. Litigation, so public interest litigation, that is not lobbying. Again, we're talking about in the court system, not lobbying. I already mentioned the special purpose body, such as a school board or a zoning board. And then there's a carve out that doesn't come in very often, but if your organization was threatened or your type of organization, you could lobby in self-defense. All right, so just checking time here. Got through the overview on the federal stuff. So now I'm afraid I'll make your head hurt a little bit. Let me just look quickly at my notes to see if there was anything else I wanted to, yeah. So
Did we want to, there are a few questions coming in, Melissa. Did we want to address some of those?
Yep,
Great.
Go ahead.
Great, thank you. Just kind of a clarifying question. If testifying at a public hearing or before a legislative body that sets up time for citizens and groups to do so, is that considered lobbying?
Yeah, it is. I mean, if you're, yes.
Okay.
You know, and it may be, at the federal level, you may be there strictly for educational purposes, and that you don't end up talking about, directing support to a particular piece of legislation. However, it gets more complicated at the state level, which I'll explain in a minute.
Great. Two more, I think, if we can get. So one, I was recently asked to sign a public letter of business leaders opposing a proposed state policy. In my official capacity as CEO of a 501c3, am I able to do that without fear of legal action, excuse me?
Yes, you are. So let me restate what I heard. So sign a letter in opposition to, I guess there's a distinction too, whether there's a question of a policy, like an implementation, compliance, regulatory issue, versus a directing the legislature to pass legislation. Both of them are permissible. The first would not qualify as lobbying. The second may be an expense to the extent that like staff time was spent on that. Research, perhaps that's a lobbying expense. But if that's a very occasional activity, then you probably wouldn't have made the 501H election. It's considered insubstantial. There is a part on Schedule C of the Form 990 that could be reported. But again, stating an opinion on whether a law is being enforced appropriately, kind of what the implications of regulations are, that's not lobbying.
Great, thank you. We'll go with one more, and I will note that there are multiple questions that we probably won't get to, but we will, I'll share those with Melissa, and we can put together kind of a Q&A sheet following up. So this is a question specifically about social media. So posting on social media about why a piece of legislation is good or bad and encouraging folks to contact their reps is not lobbying?
No, encouraging people to contact their reps is lobbying. I mean, they're telling people, if you include a call to action, so posting on social media pros and cons, stopping there is not grassroots lobbying. But if you include a call to action that it includes direction to contact their legislator and include information on how to find their legislator, that is grassroots lobbying. But keep in mind, which is a really important point I was just about to make, is this is an expenditure test. So posting on social media and having, articulating that opinion doesn't cost your organization very much money. So while it might be lobbying, it's not a big deal. I mean, now if you spend a lot of your staff time researching that position and articulating it, and there's other work you're doing that you claim is education, then you may be creating complication there by taking that extra step. But for the most part, stopping short of a call to action, it would not be lobbying.
So then a quick follow-up then. So is directly contacting a legislator and telling them how a bill directly affects your organization, would that be constituting lobbying?
Yeah, it would be. But again, from the federal standpoint, like, you do that occasionally, that's very insubstantial, right? When you think about that, you could spend 20% for a small organization of your staff time contacting legislators, discussing, researching issues. The occasional reaching out to a legislator, and keep in mind, if it's your own legislator, like it represents you personally, then it's not lobbying, even if you're talking about your organization.
Great. I think we'll keep some of these questions for a little bit later, and I think we'll move on with the presentation. So thank you, Melissa. I appreciate that.
Okay, great. All right, so moving on to the state part. So the difference at the state level is that it's not an expenditure test. It is, because it's an ethics rules, it's really about transparency and who is talking to whom and about what. I mentioned the Federal Lobbying Disclosure Act because I just want to flag that there is one, the equivalent of kind of state ethics rules. I'm not going to talk about that today, but just know that it is there. So most states, including Wisconsin, regulate only what we've been talking about as direct lobbying. That means contacting legislators, legislative staff. Does not govern grassroots lobbying. So under Wisconsin rules, no limitations on what you say to the general public about legislation. That's why that letter example is very likely not lobbying, because unless you're specifically addressing it and sending it, well, hard to get into the details about knowing more of them, but you get my points, that if it's written to the legislator, then it may be lobbying, but a minor expense. If it's a statement about the folly of particular legislation and the impact on your organization to the general public, then under Wisconsin law, it is not lobbying. And then the other thing to know is what we're talking about here is the only time you could encounter these rules and the need to report and register is if you're paying someone to lobby. Either it's part of a staff person's job or you pay a consultant. So we're not talking about volunteers here. And then I already mentioned the carve out for your own legislators. So in Wisconsin, this just, sorry, it just makes your head hurt, but you have to register as a lobbying principal if you communicate, if someone for compensation communicates with a state official. Mark my word there, it is not just a legislator. At the state level, it includes attorney generals, executive branch, and legislators. And you're attempting to influence state legislation or administrative rulemaking. And you do it more on 5 or more days during a 6-month period, either January through June 30th, July 1st through December 31st. So the idea is you have 4 free passes per 6th month. So 8 free passes a year to reach out to legislators. And you're probably familiar with this, but you see many organizations that have lobby days where they bring busloads of people to the Capitol, and you could, talk to legislators 16 hours a day, cover the whole Capitol, go to the governor's office, go see cabinet officials. And if you're doing that on, fewer than 5 days during that 6-month period, then you are not lobbying. The organization does not need to register as a lobbying principal. So again, just repeating those rules. It's like communicating for the purpose of lobbying on 5 or more days, and then to do so, probably have to register. If you meet that test, then we get into needing to register, and there's both registration for the principal and for the lobbyist. Okay, so I'm going to stop there for a second. Tom, did things light up? Any more questions on that front?
No, not yet.
Okay. All right. So I think what's most helpful is, rather than get into more detailed rules, I will tell you that the Wisconsin Ethics website has a lot of helpful guides, and there's materials. If you hire a lobbyist to do this, they're very familiar with the rules. They often will guide you on reporting and help get you registered, things like that. So for now, we're going to focus on what is lobbying, what isn't, because a lot of what I hope to leave you with is to, allow you to communicate, but stop short of lobbying so that you don't have to get into the extra work and stress of lobbying. Of registering and then reporting. So first example here is communicating with the legislator's chief of staff to get an amendment on a pending bill. I think no one would question that is lobbying. However, you could do it up to 4 times. You could contact the legislator's chief of staff within that 6-month period and not have to register. This example, you can ignore the for compensation. This is giving guidance like to lobbyists and paid staff. Oops. All right, another, communicating with the governor's chief of staff. Same thing as the example before. Again, if you do it 4 days or fewer than 5 days, then you're good. But communicating with the Department of Natural Resources about the status of a grant to your organization, applying for a grant, talking to the department about who qualifies for the grant, how you could be well positioned to get a grant, that is not lobbying. That is a carve out. It's considered a ministerial matter. That is not lobbying. Checking in on a matter that's before an administrative law judge, that is not lobbying. Circulating a mailer to the public, posting on social media, urging people to vote, to contact their legislator to vote no, that is lobbying. Oh, sorry, under Wisconsin, that is not lobbying under Wisconsin rules. That is under the federal rules. Though you see a note here that if you are registered as a lobbyist, there may be some more reporting that's related to that. And then the example I've used several times already is urging the public to vote no on the ballot issue is not lobbying in Wisconsin. It is lobbying under the Internal Revenue Code rules. However, there are also political, as they say here, political communication or campaign finance rules that get at ballot referendums. So I didn't want to give you too much leeway there. Have to throw in another limitation, but just know in general you can be involved with a referendum committee. You could spend up to $10,000 on it without having to register and report. You could contribute money to another organization. So I was very involved with the Foundation for Madison Public Schools campaign this past year. We actually created a 501c4. It's called Schools Make Madison Advocates. And so they fundraised for substantial amounts of money to pay to help run the public school funding referendum. When you are fundraising explicitly for an advocacy campaign and for, in this case, was the 501c4, those contributions are not tax deductible and they cannot be earmarked for, if the 501c3 wants to raise money for lobbying and it knows it's going to lobby, which is great, do not say explicitly in your fundraising materials that you're going to use it for lobbying. You say that you're going to use it to educate and inform and to advocate on important issues, but don't use the word lobbying specifically. And for private foundations, should have maybe said this up front, hope you didn't waste your time on this webinar, as private foundations are not allowed to lobby at all. However, they can give grants to organizations that are lobbying. They just have to be general purpose grants or for some other explicit non-lobbying educational purpose. So I'm sure many of you know this, there's all kinds of foundations that give grants to organizations that lobby, but they just have to be careful how they are positioned and represented. Those of you that get federal grants are also very aware that there's usually strict limits on federal grants not being used to cover any lobbying expenditures. So everything I've been talking about, in terms of the general rules, I recognize has another layer of complexity as you get into the accounting, but there are many accounting firms in town who know how to do that, or like I suggested, perhaps a coalition effort where all of the lobbying is focused within that organization or effort, and it stays off the books of the 501c3 organization, may be convenient for a number of reasons. All right, I have another comparison thing here, but I realized it's 20 of 1. And so I'm going to stop again to see, Tom, what kinds of questions are you seeing?
Sure, thank you, Melissa. So does direct lobbying include time spent preparing for actual communications like meetings, strategy meetings, preparing documents, info flyers to legislators?
Yes. I mean, sometimes it's a gray area because there's many, I work with many organizations that are working on issues that are just central to their mission all the time. And they're educating people about them. They're, researching best practices. And then finally, it comes to the point where there is an element of what they're doing that really needs a legislative change, but it's only a small part of it. And so there's, some ability to only attribute part of your work. There's also some rules about if you created a piece that was strictly for educational and fundraising purposes, and then later you use it specifically, explicitly for lobbying, there are rules about what its purpose was in the, initially. If you can prove or have evidence that it really was created for another purpose beyond lobbying, then maybe just the portion of expenditures relating to reproducing or distributing it for lobbying purposes is all that counts as the expenditure. There's also a carve out if something was created for work that was done 6 months prior to your actual direct lobbying, then that would not count either. So sorry, I can't give you a more precise question. I mean, a precise answer, but yes, background work does count, but not necessarily all of it, I guess is what I'd say.
Excellent. One quick one. Is there a difference between members and supporters if we are not a member-based organization?
Yes, there is. That, this whole area is Lawyer Full Employment Act, I hate to tell you. But I thought I actually had a definition. Oh, yes. So members do include persons who either volunteer more than a nominal amount and don't need to have voting privileges. I'm just going to give a wishy-washy answer there. So I do know, it's more than just whether they have voting privileges. It probably is not just, it's not just your donors. It would have to be something more than that.
Okay. And there's one question that, since we're kind of back on this slide here, there was a question that I didn't see in my previous checking, kind of along the lines with regards to 501c(h)s. So it seems like filing a 501c(h) protects 501c3s. Is there a drawback for filing?
Yeah, good, very good question. And it's not 501c(h), it's actually 501h.
I'm sorry.
Yeah, no problem.
Sorry about that.
It's a section of the tax code that was added. They just added it because there needed to be more clarity. I really don't see there being a drawback. Where there's a drawback is if you're a large organization and you're going to engage in lobbying, then there may be a drawback because the limits are too low for your organization. But otherwise, it's not like if you make the election that you have to lobby. It may be that you were active, during one session because of something going on, and then you don't have any expenses for a while. And that means, in Schedule C that, you just don't have anything to report. But if you do, then you have the convenience of being able to know that any time that volunteers spend on this doesn't count. That's not substantial, because that's not an expense. So the only things that count would be, staff time, arranging for volunteers, whatever the cost of communicating with them, renting a bus to come to town, whatever, direct expenses. So I strongly do encourage people to make the 501h election. I'll jump forward here and show you the form. There it is. The 5768 is the one-time form. Again, you have to track lobbying expenditures, but that's true whether you've made the filing or not. Even if it's insubstantial, you're still supposed to be keeping track. It just depends on which part of the Form 990 Schedule C you use. There's a part for non-501h filers and a part for 501h filers.
Great. We are all caught up.
Cool.
So if you want to proceed, and we'll go from there.
Great.
Thanks, Melissa.
Well, all of these really get at the things I was talking about in that chart. So I'll just do the quick review. See if there's anything new here. Nope, I think we've gone over all that. So these are interesting. I told you under 501h, like discussing broad social policy issues isn't lobbying under the IRS rule or 501h rules, but it might be in Wisconsin, right? Because it doesn't matter what you're saying if you're talking to a government official and trying to influence them on legislative outcome. I know it gets murky when you're just educating them, but you can assume that if you are calling them up to, inform them of how legislation will or does impact something you care about, that you should count that as an interaction. Even like scheduling a meeting technically counts. So you got to be careful about how you use your time when you're communicating with the legislative or government officials. Same with there isn't that carve out in Wisconsin for technical advice or assistance to a committee. Again, the member saying grassroots isn't an issue in Wisconsin. I guess lobbying and self-defense, that is an issue. Again, volunteer time doesn't count. If there's no paid staff or consultants, then we're not even in the realm of reporting. And tracking votes, positions taken, contributions, again, at the federal level, that's not going to be lobbying. If you're just tracking and you're not telling people what to do and you're not contacting legislators with that information, it also isn't going to be lobbying in Wisconsin because, you're not, because it's grassroots. Where it can turn political is during an election year where you are tracking selective issues and selective votes and presenting them in a way that makes that that candidate look bad or make the candidate that you prefer look a lot better. So again, you can do it. There's guidance out there. It's more complicated. We'd be happy to work with you on that. We do that a lot during election season, is kind of helping people know how to take it to the edge, but not over. And always advocating for better enforcement of laws is never lobbying, again, stopping short of specific reference to specific legislation. So already covered this, and now we're on to Wisconsin. And I'm going to just really quickly tell you, here are the general rules. I'm not going through them in detail, and Tracy is going to help us here. But really what I don't want to put Tracy on the spot for all of the ins and outs of what qualifies and what has to count, as much as giving us her experience of having to do this for forward community investments. And Tracy, tell us, how scary is it? How much of a headache is it? There's a right answer. I think you're on mute still.
It's being organized up front. So to speak about the H election, so that's the IRS's way of tracking if nonprofits are lobbying or not. So broadly, that is your activities both at the federal, grassroots, and state level. And so we track that through staff allocation of time, and then overhead allocation based on staff time, and then direct expenses for those activities. So that's where you're capturing your grassroots efforts. That's where, expenditures become important, and that piece is tracked separately. And as Melissa said, that is reported on your 990 annually. As for the state piece, when you exceed, your 5 contacts, if you so choose to, about a topic or even a budget item, or even discussions about budgets, or even broadly topical issues where you have contact more than 5 times, you biannually register as a principal. So that is not an annual registration. I believe the price is about $700 for both the lobbyist and the principal registration. An example of FCI, FCI does not technically do direct lobbying at the state level, but we do manage a collaborative. So I am listed as the principal. We hire a lobbyist. We do turn over controls to the lobbyist to submit their own time reports. This time reports are down to the day. So it is tracking the time you spent and the preparation that you do by a daily tracking record. And also, when you're doing that, the topics. So you also have to track the topics. So I should back up a little bit. So the first one here is when you are doing any lobbying at the state level, you have to submit within 15 days of contact topics. Broadly, it can be interest in a governmental, the administrative department. It can be in budgetary items. It can be actual bills. It could be even the idea of a bill coming through that you know about, but you put in like the vaguest language, like we're really concerned about, CDFI tax credit legislation, but it doesn't have a bill number. But once you get a bill number, you do have to update that. So the important part is to make sure that the topics that you are communicating about are submitted in 15 days. That is the principal's, prerogative to make sure that that is done. Your lobbyist can do that for you. If your lobbyists are your staff members, you do have to make sure that that gets done. The actual lobbying reports are semi-annual, and as I said, it will be reported by month and day. It's actually like a spreadsheet, like July 1st, July 2nd, July 3rd, the time allocation there, any direct expenses related to it. If you are paying a lobbyist, you have to report it. They do itemize out between compensation and maybe travel time and food or maybe printing costs. So it is a good, for FCI, we track that through a specific accounting accounts related to these activities to make sure that we're tracking these expenses directly and on staff allocation. So that's a semi-annual piece. You report that in. You then have to allocate that lobbyist time to those topics. So that's the other part that you have to track. And then I believe the direct expenses, the lobbyist expenses, overhead allocation related to maybe your staff time, and that is a semi-annual report. FCI proactively does the election age. You only do it once. Does not mean that you actually do that lobbying every time, but like I said, we do track it annually. We do proactively things that fall in that category. We do report on our 990. We don't always have a lobbyist at the state level. FCI or Forward Community Investments itself is not right now listed as a principal or lobbying, but as a collaborative, we are managing the lobbying reporting for our Invest in Wisconsin partners. And if you were to decide not to lobby, there is a way of, within that 2 years, you can also exit out of it. And as Melissa said, the Eye on Lobbying website is very thorough and very informed, but it's mostly around the ethics that they want to know who's doing it. And it's very transparent. You can see who else is registered for lobbying on that website. So I don't know, is there any questions specifically?
Yeah, that's super helpful. I was going to say one of the reasons you might want to terminate your registration within the 2-year period is you are required to continue to report, even if you have nothing to report. So it's a headache a bit if you're not doing it. And the other reason is like whoever's registered as your principal, so say it's your executive director, they cannot make political contributions during that time. And so I think some unintentional mistakes are made there where people forget because they're not actively lobbying and they forget that their registration is still live. And then they make a political contribution. So there's ways to fix that, but it is something to be careful about.
Okay,
Great.
And so more information, we've got that. There was one quick question that came through. What if a government official asks you for advice? Is that considered lobbying? And the time that you spend with them, obviously answering that question or sharing your thoughts about that?
Right. That's a really hard one. It depends on who the government official is, and if we're talking about state or federal laws. And, you know, I think I can tell you that I think that those types of conversations are seriously underreported, partly because people don't know. And it's like if someone calls you and you talk to them. But for the most part, if we kind of parsed it out and did an analysis, you know, it probably is lobbying. If you're, you know, talking about the pros and cons of a particular legislative proposal, and then at the state level, you know, legislative proposal or a administrative, you know, rulemaking initiative or the governor's budget, I can tell you it's a hard area to advise on, because I know that there's just a lot of conversations that happen in the community and passing. We're connected to people, we know people, and if you don't, you know, you're not initiating it. I think there's a lot of education. I will tell you the safest time to do it, and that we know is not lobbying, is between when someone is a candidate and you're just educating them on the issues. So you're not, so that's why like candidate forums, you know, you're not advocating for their election or defeat necessarily, but you're educating them on the issues, you know, between the time when they're elected and actually in office, you know, great time to be in and educating on the issues, because you're not, you know, if the legislature's not in session, you know, you're not advocating for a particular legislative outcome.
Great. There definitely is some gray area in there for sure. But yeah, so those are all of the questions.
Great.
And it's 12:58. How about that?
That's impressive. All right. Well, thanks FCI for hosting this. I do think it's an important topic. We'll share the slides, and do look at my resources page that I had back there, because both BoardSource does good work, Alliance for Justice, like we said, the Eye on Lobbying that Tracy mentioned has good resources, and so is the IRS. So great, thank you.
All right. Well,
have a great day.
Yep. And one more thing I wanted to mention too, that obviously this session is going to be recorded. All of the resources will be made available probably next week in an email and on our website. Also too, if you enjoyed this session, we're going to be continuing the advocacy track of our webinars with another one coming up in June 24th. It will be presented by Carousel Baird of Community Justice, Inc. And she's going to go over how we can prepare your policy vision and legislative agenda. So in that follow-up email, I'll also be including your registration link and a little bit more detail about that. Also, if you want to learn more about Forward Community Investments, don't hesitate to reach out and follow up with me on that email. And lastly, just wanted to thank Melissa and Tracy for presenting today, and all of you for your hard work and everything that you do in your community. Take care and be well. Bye, everybody.